Hey, Commissioners, the attendee list has populated and leveled off, so Commissioner Smith, you can feel free to start the meeting.
Thank you, Todd. Good afternoon, everyone. Welcome. The regular meeting of the Civil Service Commission for May 1st, 2024 will now come to order. We welcome the in-person and online attendees. If you want to provide oral comments on any of the agenda items, please be sure to follow the instructions on the first page of the agenda. If you're attending this meeting in person and you would like to pull an item for discussion, when asked, please stand and identify yourself by name or number, and we will return to your item for the consent agenda is approved. Attendees joining this meeting using the Zoom application will alert Commission staff for your attention, excuse me, to speak about an agenda item by using the Q&A function at the bottom of the screen. Please include your name, telephone number, or other identifying feature you selected when logging in, and the agenda item number that you want to speak about. Attendees who dialed into today's meeting, please press *9 on your telephone to raise your hand to alert Commission staff of your intention to speak about an agenda item. When called upon for you to speak, please unmute yourself using *6 on your telephone. We will now commence with the order of business. Will the Commission Secretary please take the roll call?
Commissioner Coleman,
Present.
Commissioner Fletcher,
Present.
Commissioner Johnson, Commissioner Rodriguez Kennedy,
Present.
Commissioner Smith.
Present. All right. Approval of the minutes. May I have a motion to approve the minutes of the meeting of March 6, 2024?
So moved.
All right. Thank you, Commissioner Rodriguez Kennedy. Do we have a second? Okay. Thank you. Is there any discussion? Seeing no discussion, will the Commission Secretary please record the Commissioners' votes?
Commissioner Coleman,
Aye.
Commissioner Fletcher,
Aye.
Commissioner Rodriguez Kennedy,
Aye.
Commissioner Smith.
Aye. The minutes are approved by unanimous consent. Now, for the non-agenda public comment. Members of the public may address any matter relating to the Civil Service Commission other than items that are on today's agenda. The total amount of time allowed for public comment will be limited to not more than 2 minutes unless I, as the Commission President, agree to extend the time frame. Do any of the attendees want to make a public comment about any matter relating to the Civil Service Commission, but not on today's agenda? Seeing none in attendance, so if so, and you join the meeting using Zoom, please use the Q&A function on the bottom portion of the screen to inform Commission staff. If you dialed in today's meeting, you may press *9 on your telephone to raise your hand to alert Commission staff. When called upon for you to speak, please unmute yourself using *6 on your telephone. Now, we will need to wait a minute in the event somebody wants to make a comment and is attempting to alert staff now. I will ask the executive officer to please start a timer.
Sure. Commissioners, 1 minute has passed and we've received no request to make a public comment.
Okay, thank you. Hearing none, we will now move on to the agenda item discussion. Do any of the attendees want to pull an agenda item for discussion today? If you're attending this meeting in person and you would like to pull an agenda item for discussion, please stand and identify yourself by name or number, and we will return to your item after the consent agenda is approved. Anybody? No one today? Okay. If you are an appellant or you're speaking for an appellant or a complainant, please use their assigned number. If you join the meeting today using Zoom, please use the Q&A function on the bottom portion of the screen to to inform commission staff of the agenda item you wish to speak about. If you dialed into today's meeting, you may press, like before, *9 on your telephone to raise your hand to alert commission staff. When called upon for you to speak, please unmute yourself using *6 on your telephone. We will need a minute in the event somebody wants to pull an agenda item and is attempting to alert staff now. And again, I'd ask the executive officer to please start a timer.
That'd be my pleasure. Commissioners, 1 minute has passed and we've received no request to pull an agenda item for discussion.
All right, thank you. Okay, so now move on to the formation of the consent agenda. Will the commission secretary announce the items forming the consent agenda?
Commissioners, Agenda 2 is automatically pulled for discussion. Therefore, agenda items 1 and 3 through 7 are available for approval on the consent agenda.
Thank you. May I have a motion to approve the consent agenda?
So moved.
All right, thank you, Director Coleman. Do I have a second?
Second.
Right, thank you, Commissioner Fletcher. Is there any discussion? Hearing none, will the commission secretary please record the commissioner vote?
Commissioner Coleman,
Aye.
Commissioner Fletcher,
Aye.
Commissioner Rodriguez Kennedy,
Aye.
Commissioner Smith.
Aye. Consent agenda is approved by unanimous vote. We're now on to the discussion items. The first is agenda item number 2, which is my report on the Citizens Law Enforcement Review Board appeal hearing. Do any of the attendees want to speak about this agenda item? If so, you join the meeting using Zoom, please use the Q&A function at the bottom portion of the screen to alert commission staff. If you dialed into today's meeting, and you may press *9 to raise your hand to alert commission staff. We will need to wait a minute in the event somebody wants to speak about this agenda item and is attempting to alert staff now. And I ask again the executive officer to please start a timer.
Sure.
While waiting with the timer, I forgot to ask if anybody attending would like to speak to. No, we're okay. All right. You don't even have to push *9 or *6 or anything.
Commissioners, 1 minute has passed and we received no request to speak about this agenda item.
All right, thank you. Okay, this is my hearing to make the presentation? I'm going to ask Commissioner Rodriguez Kennedy, as the Vice President, if you will please chair this portion of the meeting as I read my report.
Yes, please proceed with your report, Commissioner.
Thank you. All right. Employee 2023-45P, a deputy sheriff, appealed the findings of the Citizens Law Enforcement Review Board group, that is also known as CLERB, in which it sustained alleged allegations against the employee in the sheriff's department. The commission appointed me, Commissioner Peter B. Smith, to hear the appeal and submit findings and a proposed decision to the Civil Service Commission. Therefore, a hearing was held on March 21st, 2024, and both the employee and the clerk were represented by counsel. The Commission authority to hear this appeal is derived from the Civil Service Rule number 15, section 15.1.1G, and that the clerk finding charges employee as follows: use of force resulting in great bodily injury, deputy used force resulting in injury. Specifically, clerk found employee violated the use of force policy in that he used more force than necessary while escorting an incarcerated person, which is also known as the IP, which resulted in injury to the IP. Section 15.1.7 states as follows: the burden of proof shall be on clerk to demonstrate through a preponderance of the evidence that the incident or act, which was the basis for the complaint sustained by clerk, occurred and did constitute improper conduct. Summary. Clerk reviewed this case and found misconduct on the part of the employee as follows. On December 29th, 2022, while transporting an inmate, the IP, within the George Bailey Detention Center, also known as the GBDF, the employee used unreasonable excessive force when he forced the IP to the ground, resulting in a laceration to the IP's eyebrow. Clerk's evidence was offered through documentary exhibits and testimony of 4 witnesses, its special investigator, 2 deputy sheriffs, and a sheriff's sergeant. The employee offered documentary exhibits and produced additional evidence through his own testimony. The employee disputes the finding of his use of force against the IP as unreasonable or excessive. He also disputes that he used improper takedown techniques when using force resulted in the IP striking his head against the floor. The employee asserts that prior to the transport to the infirmary, the IP was involved in 2 fights with a fellow detainee. Fellow detainee is also known as the fellow combatant, both of whom were housed in Module 6C. That the IP was uncooperative in the cell where the second fight occurred and would not comply with the directives and admonishments from the employee and other deputies, that while escorting the IP to the processing at the infirmary following the second fight, the IP would not walk on his own, forcing the employee and a fellow deputy to support him by holding the biceps to prevent the IP from falling, and that the IP made threatening statements to the employee and other deputies. The employee asserts that throughout the employee's involvement with the IP, there was continued assaultive behavior on the part of the IP, and that he spoke with him throughout the transport to calm him down and obtain his cooperation. He points out that the 2-second incident where the IP went from pressed against a cell door to when the IP was taken to the floor should be considered in the totality of the circumstances. Policies. All parties agree that the San Diego County Sheriff's deputies are bound by the San Diego County Sheriff's Department's Policy and Procedures Manual. Specific to this appeal are procedure sections relating to treatment of persons in custody, use of force, and addendum section F is the use of force guidelines. All parties also agree that the California law allows that peace officers may objectively reasonable force to effect an arrest, to prevent an escape, or to overcome resistance. The findings. The Commission agrees with the employee that when CLRB conducts an investigation into the use of force by county peace officers, they must consider the totality of the circumstances. The totality of the circumstances in this matter include the following. On December 29th, 2022, between 9:17 and 9:30, the IP and his fellow combatant were both housed at the GBDF in Module 6C. And then on or around 9:17, the IP and the fellow combatant engaged in a fight in the day room. At some time between 9:20 and 9:21, their fight continued in a cell on the 2nd floor of Module 6C. Module 6C of the GBDF is used to house the most violent inmates or those committing the most serious of crimes. In response to the fight, 4 deputies responded to the fight between the IP and the fellow combatant. 3 of the deputies, the employee, Deputy 1 and Deputy 2, arrived in the day room of the module and, after climbing the stairs to the second floor, entered into the cell where the IP and the fellow combatant were fighting. After breaking up the fight, the fellow combatant was handcuffed behind his back, then positioned outside of the cell, face down in the corridor. The deputy originally posted on the day room floor joined those on the second floor and escorted the fellow combatant out of the module. The fellow combatant was cooperative and walked on his own, with a single deputy accompanying him to the infirmary. The IP actively resisted cooperating with the deputies and would not comply with the directions, admonitions, or commands of the 3 deputies, including the employee, as they attempted to handcuff and remove him from the cell in order to transport him to the infirmary for processing. While en route to processing the IP, the IP willingly refused to use his legs to walk, requiring the employee and the deputy 2 to each support his body weight by grasping his biceps and guiding him through the entire time. While en route to the infirmary, the IP was directing verbal remarks to the employee, including comments to the effect of, quote, remember this day, that, quote, today was the employee's last day, and I'm going to find you. The employee understood these comments from the IP to be threats of physical harm that might come to him. In response, the employee repeatedly tried to calm the IP by assuring him that he was only going to the processing center following his fight with a fellow combatant and to cooperate. An assault can be verbal threats where it includes the possibility that the person making the threats can physically harm the victim. The IP acknowledged that despite being handcuffed in the back, it was possible for a detainee, such as himself, to cause physical harm to guards. Upon entering the corridor for the processing of the infirmary, the IP's body twisted subtly and veered to the left. This caused Deputy 2 to lose his grip on the IP's left bicep. The employee reached, grabbing the IP's shirt beneath his left shoulder and control this sudden body shift with both hands, which resulted in a counterreaction, swinging the IP's body toward the wall and the door on the right. From the IP's sudden body movement to the left to the employee's reaction to the movement, resulting in the IP's face and body being forced into the wall and middle door. Only 1 second passed. Only one more second passed while the IP's body was pressed into the wall and middle door by the employee, and during the passage of another second in time, the IP's body moves backwards as he has fallen to the floor. While briefly holding the IP pressed to the metal door and the wall, the employee felt the sudden movement from the IP. He described this as a movement of head and shoulder, which he interpreted as an effort to commit battery on either himself or the other deputies. To protect each of them, the employee initiated a takedown technique to gain control of the IP and prevent further actions of resistance. Applicable training and policies support that a takedown of a struggling, uncooperative person, even with handcuffs, is appropriate to gain control of the situation. At that point, the IP body was collapsed to the floor, but prior to his head making contact, both of his feet were visible, pointing at approximately 45-degree obtuse to the wall and metal door, with no sign of entanglement with each other or anything. At the same time, just prior to the IP's head striking the floor, the employee is standing in the middle of the corridor with both feet planted on the ground, with both hands holding on to the IP's shirt. As a result of his head striking the floor, the IP sustained a cut to his portion of his head across the outside edge of his left eyebrow, which required 9 stitches that must be performed at the hospital, not the infirmary. The IP was transferred to the hospital after being interviewed by the sergeant. While there is some speculation that the employee used a leg sweep as the takedown technique to gain control over the IP, the video evidence fails to support that the employee used such a leg sweep. Further, the employee has consistently identified his takedown technique as hands-on and pulling the IP to the ground, which is supported by the video reflecting both the eyepiece feet together at a 45-degree angle to the wall and the position of the employee with his feet planted in the middle of the corridor. It is more credible that the employee could not have used a leg sweep in so few seconds that he would end up with both feet in the middle of the corridor. It is also more credible that the employee utilized a hands-on and pulling approach to take the IP to the ground, which is also an acceptable technique. Further, although the IP suffered an injury to his head requiring 9 stitches, such that the procedure could not be conducted at the GBDF infirmary, there is no accepted definition of great bodily injury in either the Penal Code Section 835A or Section 4.3C of the CLRB rules and regulations. However, even if a cut on a person's forehead requiring 9 stitches could be considered great bodily harm, by some, the Commission hesitates to make that threshold to apply here. Experience and common sense support that the most vulnerable and easily cut areas of a person's body, eyebrow, chin, skull, knuckles, elbows, knees, etc., or where the bones are closest to the surface and the skin and they are struck by a hard object, including another person's head, the ground, or another hard surface. In summary, as the hearing officer, I cannot support that the IP suffered great bodily injury due to the takedown performed by the employee. However, even if the cut to the eyebrow area of a person's face requires 9 stitches could be defined as great bodily injury, the takedown technique used by the employee is more likely not a hands-on pulling maneuver as consistently reported by the employee, is more likely a hands-on pulling maneuver as consistently reported by the employee from the initial report. His supplementary report, his CLRB sheriff employee response form, and the testimony of the hearing, which was necessary when considering the totality of circumstances in the short period of time. As the hearing officer, it is my opinion that if CLRB had the benefit of hearing the employee and other witnesses provide testimony in an interview during the investigation, as I have had the benefit of receiving during the hearing, CLRB might not have concluded the employee's use of force against the IP was unreasonable or excessive, or might not have sustained that allegation. I have just a little summary before I give you my final recommendation. I've been on the Civil Service Commission for 6 years, and this is my first CLRB issue I've worked on. In my opinion, I find the process to be very interesting, well-intended, but I do believe that it is, to a certain extent, flawed. In this case, I found and felt the investigator for CLRB was very conscientious, professional, and had no bias or goal other than to do the right thing. I believe that. On the other side, I also found the sheriff's deputy to also be very conscientious, professional, and had no bias or goal other than to do the right thing as well. And I believe he thinks he was doing the right thing. Both the CLRB investigator and the sheriff's deputy were very credible witnesses, and I believe their testimony was truthful and straightforward. In addition to several hundred pages of exhibits outlining witness statements, rules and regulations, training procedure, there were 6 videos from surveillance cameras and a recorded phone interview. We also heard from 5 witnesses that were either at the scene or had direct participation in gathering statements. All of the witnesses were well-spoken, and there was no indication that they were not telling the whole truth and nothing but the truth. This is a lot of information to review for an action that took less than 3 seconds. In my opinion, based on the circumstances leading up to and during the incident, the prior training of the officer's years of experience, corroborating testimony from the witnesses, that the action taken by the officer was appropriate and consistent with his training. I found no evidence of abuse of authority or inappropriate force. Having said that, based on the findings set forth, I hereby make the following decision and recommendation that the allegations of use of force sustained by CLRB in the complaint against the employee referred to as the CLRB case 23-010 be deemed not sustained, and that the proposed decision shall become effective upon the date of approval of the Civil Service Commission, and I so move.
Is there a second?
I second.
Okay, so is there any discussion? I will discuss then. So I have some questions about the overall process. One of your decisions, one of your points is that CLRB did not have access to the interviews, or no, to the, what did they have? They didn't have access to, didn't have the benefit of the actual interviews, like they didn't conduct interviews. Is that because CLRB doesn't do that, or why is that?
Well, as I mentioned in there, that I believe that the process is flawed to a certain extent. That part of CLRB's investigation, they have the right to ask, for instance, the claimant or the person involved, the sheriff's deputy, if they'd like to be interviewed or take part in their process. In this case, which is their right, they declined not to. And that's why I said in my statements that I fully believe, I think that if the CLRB investigator had access to all of the information prior to the hearing that he had at the hearing that we were privy to, as long as the testimony of the other collaborating witnesses, that I can't speak for them, but I'm not sure that they would have sustained the finding that they found.
Okay, so the deputies involved, the employees involved too. There's three deputies and an employee, or is it it's just the one?
Just one deputy.
The one deputy. So the deputy involved declined to participate in CLRB, and then CLRB did what?
And I'll defer to Tom for the technical side.
Well, they conducted their investigation with all the information that they had privy to them, included, videos from the jail system. They had set out some written questions, and they received responses in two different forms from the subject deputy, the employee, and then also the other deputies that were escorting the incarcerated person. So with that available information, they came to the conclusion that they came to. They did not have the benefit of interviewing the employee or the witnesses as per their right. They declined to participate in an interview with CLRB. So they worked with the information that they had.
So so did all of the employees decline to participate in CLRB, or just the respondent?
It's my understanding that all of them declined to participate in an interview. They all participated with filling out forms, answering written questions, but they did not participate in any interviews during the investigation.
I believe CLRB has the ability to subpoena them, correct?
They do not, I believe, have the ability to subpoena them. Do you? They do. I can't speak about their subpoena authority. I do know that it is their agreement with the sheriff's department that they can ask if they want to be interviewed, but that the deputy sheriffs can decline that, and that is okay process.
I'm under the impression that CLRB does have the ability to subpoena.
The only thing I would respond to that, there was no evidence of that brought forward to the hearing.
Right. I guess.
Discussion that they would do that or did not.
Right. So these are process questions associated with how we get to you, to your consideration. Not to your specific consideration, but how it made it to your consideration, as opposed to really having anything to do with your consideration per se. My concern, or my question, I don't have a concern yet. So my question right now, or my understanding right now, is that CLRB or deputies, employees can decline to participate, which in general they could with us as well. But just like us, CLRB has the ability to subpoena them in furtherance of their investigation. And what I'm hearing is that CLRB decided not to, or did not.
I don't have enough recollection to be able to accurately tell you what CLRB did with regards to their subpoena power.
Okay. So, okay. I guess if they subpoenaed them, they would have interviews.
I would
Right.
feel that that's
That would be my understanding.
Yes.
So moving through to the actual recommendations, I can understand. I understand the statement that if CLRB had access to the information that you had, they might have made a different decision. I fail to understand why that would be in this report, because it would be two independent bodies determining what another independent body may or may not have done based on information they apparently did not receive. So I'm curious. I'm concerned about making that sort of determination for CLRB because I don't want to speak for another independent body about what they may or may not have done with information we do not have. At this point, it's unclear whether or not they knew or they could have subpoenaed them. We don't know that. We know that they don't have interviews. So there may be, I think to your point, there may be some serious flaws in the process because if you don't have interviews or you can't subpoena them to conduct interviews, then you can't really make a decision in, as you said, the totality of the circumstances. I can understand that. But my first concern is that in the report, it says that we're opining on what CLRB may or may not have done. And I just don't know that to be a fact in this matter. In addition to that, I have a concern about I'm not concerned yet. I have a question about the determination associated with great bodily injury. Now, as I understand it, and because I did some research, that is kind of a gray area. Like I looked up the case law, and I think the last ruling on it, the Supreme Court said basically it's for a jury to decide whether or not it's great bodily injury, and gave a couple of examples. But there are significant examples that suggest that in different cases, courts have ruled that injuries requiring stitches and medical attention are great bodily injury. So I guess my question is, other than the stitches, the 9 stitches that they required in the hospital visit, do we know of any? Did he receive a concussion? Did he get an infection as a result of those stitches? Is the person alive? I have no idea. What constitutes the full disposition of this patient?
I can tell you from the testimony and the information given, there was no injury stated other than the 9 stitches. The only other thing that was mentioned was that the injured person did not elect to press charges against the deputy. But there was no stating anything else but his condition.
So the injured person decided not to press charges with the deputy. So how did this get to CLRB? Someone reported them, or is it automatic?
It was automatically reported to
Okay.
CLRB by the sheriff's department. They made the determination that it took off enough boxes to automatically send this incident to CLRB for investigation. So that's how it got to CLRB. There was no complaint made by anybody, the incarcerated person or anybody else, with relation to this incident.
Is it the policy of CLRB or the policy of the county that all incidents of that include use of force are sent to CLRB? Is that the policy? Or is it just the sheriff's department in their command authority decided this is probably something we should send to CLRB?
Yeah, wait for counsel.
Yeah, I'm not sure the record truly reflects all of the answers to your questions, Commissioner, but my understanding, based on what I saw in the record, is that the sheriff's department provides a use of force form. They fill it out anytime there's a use of force. It doesn't have to be excessive, and it doesn't have to cause injury. It's when you use force, and clearly this was a use of force in order to take the gentleman down. Right. So once they give that report, prepare that report, they forward, and my understanding is they forwarded that to CLRB, which is part of the protocol, and then CLRB will take that and decide if they want to investigate the circumstances of the case, as they did here.
So basically, they report all of these use of force incidents, and CLRB gets to determine which cases it takes up and not.
Correct.
Okay, so like
Unless there's a complaint, then they still have that choice if somebody makes an actual complaint. But this is the sort of self-reporting procedure.
So it's good to know. So this is important context. So understanding the record now, the IP did not press charges against the deputy. Okay, so the IP themselves is not pursuing this.
That's correct.
The IP is alive.
Yes, it is our, we have not
I don't know.
received any testimony.
It was not in the record.
We did not receive any testimony that there were any difficulties of him recuperating from that injury.
Okay, that's sort of a grim thing to ask, but it was not clear from the record. Okay, so the IP is not pursuing charges. The IP is alive. The CLRB did not have access to interviews and apparently did not use their subpoena power to get those interviews and instead relied on a questionnaire, basically an inquiry, back to the department, to the individuals in order to get the information that they needed to make their decision. Is that my understanding of the facts?
That sounds accurate.
Okay. So I concur with the process being flawed. I think we have a situation where CLRB is not exercising its the full totality of its power. And if they're not exercising the full totality of their power, they probably aren't coming to, they can't give, they did give a determination, but it's then fair to say that maybe that determination isn't all the facts and you have new information that you're considering, which is what appellate bodies do. So I get that. I still am, yeah,
I can interject.
go ahead.
Have we determined whether or not they do have subpoena power? Or are you surmising that they do?
Part of the record was a copy of the ordinance that's been adopted. I can't remember for the ordinance, but in it, it gives the power. CLRB, let's go back. CLRB is a charter commission. It's created by charter, by citizens' approval, a vote to amend the charter to add it. And then to implement that, the Board of Supervisors has adopted ordinances to and sections in ordinances to give them the direction that they need to exercise their authority. My recollection is in there, it is they are given the power to subpoena. Also in the record was information relative to an agreement between the Sheriff's Deputy Association and CLRB some time ago. It dealt with the issue where sheriff's deputies are forced potentially to testify against themselves, and it's not an interrogation by the department itself. So there was a mediation and negotiations that resulted in an agreement that sheriff's deputies could exercise their right against self-incrimination, presumably, and not and decline to participate in an interview process, subpoena or otherwise. And that was what was resolved in order to apparently to get past that issue. Otherwise, CLRB would be subpoenaing every law enforcement officer each time, and then you'd have this constant conflict whether they should be considered interrogating them as part of a disciplinary process. And discipline has not come from CLRB. The discipline comes from the Sheriff's Department. So remember that CLRB is reporting. They cannot impose discipline, I don't believe. I think so. They simply make a report, and then the Sheriff's Department would be still in the department to determine whether discipline should be imposed.
Okay, so that's a lot of information that's helpful to know. So they declined to participate in CLRB, but they decided to participate in the Civil Service Commission. My question now, in terms of our authority, if we were to subpoena them or to order them to come, they would comply with that order because they do.
They would,
Okay, why?
because we have a subpoena authority. The employee who requested the appeal can be compelled to answer questions regarding his own
He's
appeal,
pursuing it.
and he was pursuing. the
Okay,
appeal.
okay. Okay. I guess in terms of my determination here, in terms of my vote, I think in the grand scheme of things, first of all, I don't have the record, the full record of the item. But that being said, I disagree with the agreement or with the statement at all that this was not a serious bodily injury. Not only because there is case law that suggests it, but also because if we were to think about it and think about, say, if a deputy caused, I don't know, 9 stitches and a head injury to, I don't know, my child or my sibling, I might consider that a serious bodily injury. And the courts have let us determine that on a case-by-case basis. So I do think it's a serious bodily injury or a great bodily injury, which is different from serious according to the courts. But that being said, according to your determination is even if there was a great bodily injury, it's unclear that the deputy erred in terms of policy, which I do not dispute based on the record. I don't know that I can make that determination. So I could not support this as long as it makes in terms of its totality, I could not support this document with my vote as long as it makes a determination that this is or is not a great bodily injury because or that it is not a great bodily injury because I think that it is. So I would not have even opined on that. And I certainly couldn't support it if it makes a statement that suggests that a completely different independent body would have done things completely differently if they had the information available to them, because they could have had the same information available to them and come to the same exact conclusion, depending on who we're talking about and what they're feeling at the time. So those two reasons would lead me to not support this vote. But I generally think that this was well put together. I think your arguments are correct in terms of, or your assessment is correct, that the process is probably flawed and needs to be corrected. And I think we should probably have some sort of information session or something to get a better understanding about their process. I do have questions about why about their process, and I probably would submit that later on.
And Blake, maybe Clerk to come here and tell us what their process is. And that could be something we can look at in the future.
Right. Okay, well, thank you, and I'll look into that. So is there any further discussion, or did you, yes?
Just one clarification. I think it might be helpful with your two issues that you object to. Just again, clarifying what my position was in the opinion. As I stated in there, as the hearing officer, it was my opinion. So it's not the reports. This is my personal opinion based on what I had observed that I believe is possible that Clerk would have come to this decision. So I wasn't saying that as a matter of fact, that was my opinion. I got that opinion based on the testimony at trial, the questions they asked of the witnesses. Some of the issues they weren't familiar with. So I believe that based on my observation of the testimony.
Yeah, and to be clear, I think it's fair to have disagreement on the opinion. I think that people can see the same injury and come to completely different understandings of that, and that's why the courts have left it up to juries to decide, or in this case, us. But if I were to vote against it, it wouldn't be because I disagree with you expressing your opinion. I would disagree with the precedent set that this might not be about a great bodily injury.
Okay.
It would be less be about the opinion and more about precedents. So if I were to like write this report, I would have not included that. I would have focused on the policy. It's unclear that the deputy violated the policy. And if it's unclear that the deputy violated policy, it doesn't matter what the clerk would have done. It doesn't matter whether or not there was a serious, great, or not an injury at all. The deputy didn't violate policy. So like, that's why I'm torn here. Like, I kind of just want to, like, I could see myself voting yes, because it's unclear that the deputy violated policy, but there was a great injury. The process is flawed. I don't know. There's a lot of reasons to vote yes, but not with like this construction of the report. So that's all I have.
I think we were trying to say with a great bodily injury,
Right.
is whether it was great bodily injury or not. The other facts don't justify the allegation against him. So whether, even if you came to the determination it was great bodily injury, he was still following procedure, doing his training, doing everything he was instructed to do, and the totality of the circumstances justified his actions. So even if it resulted in great bodily injury, I think that is the outcome. That is really the question that we're looking at here now today.
Okay.
Was his actions justified?
I think that's
I believe they were.
Commissioner Fletcher.
Commissioner Rodriguez Kennedy, I have a question for you regarding, we can debate the term great bodily harm, but do you question that the officer's force was proportional? That's question number one. And two, do you think that it's possible to use proportional force justly and the inmate end up with a 9-inch scar, regardless of whether we think it's great bodily harm or serious injury or what have you? Is it possible to use proportional force, be just, and the outcome be a 9-inch scar?
It's not a nine, it's 9 stitches.
9 stitches, yeah.
Talking
9
about a very,
stitches.
very big,
9
that would,
stitches.
a 9-inch scar would absolutely be,
Right,
it would be great bodily injury. And to answer your first question, it is completely possible that the officer could have used proportional force. And there could be an injury from that proportional force, especially considering that the person is resisting. So yes, that is an objective yes. And then your second question was, what was your second question?
Second question was, I think you just answered.
Okay, so I took them together.
So with that, I think that's where the leg sweep comes in. The leg sweep is a question of the proportionality, not necessarily the outcome, not necessarily the great bodily harm. If he did not do a leg sweep, which we believe that which, you know, the record shows it's really difficult to do a leg sweep in 1 second unless you're Bruce Lee. If he did not do a leg sweep and he did a legal move, we can question whether the move should be legal, but you know, he did a legal move. We're not really questioning whether the move was proportional or disproportional. It seemed proportional if it wasn't a leg sweep. The outcome was 9 stitches. So do we vote no because of 9 stitches and a definition of great bodily harm when the officer, in my opinion, used proportional force to mitigate an issue? The result, nobody wants to see anyone have 9 stitches, but the result of the officer correcting a dangerous situation, unfortunately, ended up with a gentleman in the hospital. So do we hold him accountable? Do we criticize? And I don't want to get into too far into other issues. I think a no on this is to say, yes, you use proportional force. Yes, you were addressing a difficult issue. But anytime you do anything right, if it ends up with 9 stitches, I'm going to vote no. And I'm not sure that that's the approach that this commission wants to take.
I think that's a very good point. My question, but also I didn't focus on that part. I didn't really factor in the leg sweep part. And also we're not even determining whether or not a leg sweep occurred. What we're determining is it's more likely that they use the pulling down thing, which is very common, as opposed to a leg sweep. I didn't see that video. Did the officer use leg sweep? Because here's what I don't accept. A leg sweep taking more than 3 seconds, 1 Mississippi, 2 Mississippi, 3 Mississippi. I'm a Marine Corps combat veteran. I know for a fact I can conduct a leg sweep in that time. We can absolutely do that. That is completely within our power. It actually takes about a second. It could take a second to do a leg sweep. A leg sweep is that.
I think the contemplation wasn't just the leg sweep. It was where the officer ended up after the leg sweep within the time frame.
I don't know about that.
It was whether or not the use of force in itself was justified. And in this case, Commissioner Smith found that it was. The video,
so the leg sweep is
appeared
legal.
that the leg sweep was not used, and it looked like it was a hands-on takedown. The preponderance of the evidence that was brought to the hearing yielded the conclusion from Commissioner Smith, and our review of the video confirmed that there did not look like there was a leg sweep, and so that's how he came to that conclusion.
So like I said, like that's why this is a confusing report. Is a leg sweep tolerable? Like, could a deputy? Because I think that makes sense. Actually, a leg sweep could be a completely legitimate thing for a deputy to do. So why are we talking about leg sweeps?
If I can clarify, it's my understanding is that there was a discussion that a leg sweep was used, and that is, in my understanding, acceptable procedure for this type of bringing a IP into control. The reason there's a lot of discussion here is in my mind, from viewing the video, there was no evidence in that video that a leg sweep was used. It was more the other technique, which was the physical takedown, which both are acceptable.
Okay. So now we can't even identify a move or a thing that was out of policy at all. Okay. All right. I think I have
You good?
Yeah, I think I'm good. Oh, and I'm in charge, so.
You are.
So, so is there any further discussion? Will the commission secretary please record commissioner votes?
Commissioner Coleman,
Aye.
Commissioner Fletcher,
Aye.
Commissioner Rodriguez Kennedy,
Aye.
Commissioner Smith.
Aye.
Okay, that passes with a unanimous vote of the commission with Commissioner Johnson absent. Thank you for the entertaining, the discussion, the thorough review of that case, and I will yield the chair back to you.
Thank you, Commissioner Rodriguez Kennedy. I want to acknowledge your comments, and ever since I've been on this commission, I've always strongly supported a thorough discussion of how we come to the decisions we come to. I don't think it does the members of this organization any good to just stand up here and just say aye, yes, and have no discussion. I think this is a very healthy thing, and frankly, I'd like to see more discussion on every agenda item to see what the thought process is. That's how you modify behavior. That's how you keep in line with the rules when we explain what rules we're following. So I think it's a good, healthy discussion. And having said that, the meeting's concluded for today. And we are now scheduling for July 3rd will be our next meeting. We will not be meeting in the month of June. So, thank you all for coming, and thank you for participating.
Thank you, commissioners.